They're getting pressure, but they haven't capitulated yet. The SEC and the Biden administration in general is making the smallest, most non-substantive moves possible to try and placate the crypto vote without actually doing anything that's favorable and lasting.
This content is brought to you by VeChain, which is a leading enterprise-grade Layer 1 public blockchain spearheading a digital revolution from a sustainable, highly scalable smart contract platform. The VeChain blockchain has many unique features, which makes it an ideal choice for Web3 applications. VeChain is working with many great enterprises such as PwC, Givenchy, BMW, and Walmart China. Most recently, they partnered with the Boston Consulting Group to build a revolutionary decentralized application ecosystem. I'm a big believer in this project. I have been since 2018. I've been a VET token holder for years. And this blockchain is highly scalable, great with security and speed, and it has low energy consumption. If you'd like to learn more about VeChain, please visit vchain.org. Link will be in the description. Welcome to the Thinking Crypto podcast. I'm your host, Tony Edward, and with me today is attorney Fred Rispoli, who's the founder of Hodl Law. Fred, great to have you back on.
It is a pleasure to be back on with you, Tony.
Fred, we've of course talked over the years about different cases as it relates to the SEC, and the most recent is of course the SEC versus Ethereum, and supposedly they have dropped their investigation into ETH as a security, or Ethereum 2.0, and I guess some of their investigations around consensus. You had some thoughts. I saw your tweets. Tell us about this.
Sure. You got to realize that this is not what it seems. And I would say that in the backdrop of the Biden administration has been very anti-crypto. Everybody is aware of that. But they've been doing a couple of things lately where you thought, oh, maybe they're not as anti-crypto, or they're trying to be less anti-crypto as we thought, which is we got SAB 121 passed. We didn't think there was going to be a veto. We got the Ethereum ETF quasi or halfway approved. Yeah. But what I would caution is that I think this is just kind of a head fake. How much can we look pro-crypto without actually being pro-crypto? And what can we do kicking and screaming in order to do the least amount of pro-crypto actions that are possible? And so obviously, because you get the veto with SAB 121, you get this Ethereum ETF that is still kind of dragging along. It's still unclear when exactly it's going to be fully approved and go in. And this lawsuit against Consensys is the exact same thing. And what I mean by that is the investigation was quote unquote dropped, in the sense that we have a one-paragraph letter from the SEC saying this particular case with a particular case number is done, and they are not going to recommend an enforcement action. Well, we don't quite know how many investigations are ongoing against Consensys or any of the Ethereum foundations. We have Consensys saying this was not anything to do with MetaMask and staking, so we still have that issue out there.
Sure.
And of course, the SEC, because of the way it's been acting lately with crypto, you don't know what it's going to do at any given time. This is a one-paragraph letter, is not set in stone for anything. It's definitely good, but it's not set in stone for anything. And what's critical is that the Consensys people said, we are still going forward with our lawsuit in Texas. And the lawsuit in Texas is exactly the same lawsuit that the SEC would have brought against Consensys. So with the burden of proof shifted, and the threat of penalties are not as worrisome as they were if the SEC was bringing it. And so it's not going to be an enforcement action, but they're suing the SEC over the exact same thing. And this is very similar to the lawsuit our firm has against the SEC.
Right.
And so what we don't know is what was going on between the lawyers at the SEC and Consensys as to do with this Texas lawsuit. Because if the SEC is still very anti-crypto and they're still going to go after Ethereum, then you're going to see this lawsuit go forward, and you may even see not move to dismiss it like they did in the Hodl Law case. And we're going to find out, we should find out either at the end of June or early July. The SEC has to file a response in Texas. And so they're either going to move to dismiss it, saying Consensys doesn't, same thing against our firm, Consensys doesn't have the right to force us to make a decision on Ethereum. Then everybody knows that they're still kind of keeping things hidden.
Sure.
Or they'll come right out and say, yes, they won't even try and dismiss it. They'll say, here's the answer to your complaint. Ethereum is a security, and then it's off to the races. I think that they're going to probably try and move to dismiss to keep everything in a gray area. But the fact that that case wasn't withdrawn and that Consensys is pursuing it tells you that it's still an open question.
Fred, there's so many layers to this onion to peel away because it goes back to Bill Hinman, right? And could the SEC also be trying to avoid any of these things being brought to light and them looking like hypocrites or fools that they did this in the past? Now they're trying to say Ethereum is a security, but also Gensler is stuck in a rock and a hard place because he could get sued if he denies the Ethereum spot ETF. And the only legal basis I could think of that him denying would be like, oh, well, Ethereum has this issue in these lawsuits that is potentially security. Not saying a security can't be in an ETF, but the same principles that were used against him with Bitcoin could be used with Ethereum. So it's like they have to keep things in a gray area because if you go in one direction, oh, this brings up this problem. What did you do in the past? And do you want to get sued by BlackRock and Fidelity and so forth? I don't know if you agree with me there.
Now, you're 100% right. And the one thing that we both know, but you didn't mention, was that the SEC has no shame. So it doesn't really matter what it argues. It can be completely contradictory. It has no shame because it has no accountability. And you don't have to look any farther than the debt box case for that. Even after they got caught with their hand in the cookie jar, they still tried to lie to get out of it. The judge slapped them with a huge fine and they shut down their entire office. But, I mean, hopefully something does eventually happen. The government does work slow, even if it is going to hold someone accountable, but there's been zero indication that there is going to be true accountability. So bringing that back to what you said, the SEC could slow play. I don't think it will, but the SEC could slow play approving these S1s. And then at the very end say, actually, we don't think that you've really done everything you could and no ETF. And then somebody's got to sue them. And that just delays everything. It's just a great way to prolong everything. I do think they're going to approve the S1s, but we still got to figure out exactly what that's even going to mean. And the devil's going to be in the details because, everybody that's saying, oh, Ethereum's not a security because there's language that's in a commodity trust in the Ethereum ETF. Well, that doesn't mean anything because Coinbase said we don't deal in securities on our platform. And the SEC is like, great, we're going to improve your S1 statement. You're good to go. And then they sued them. So, I mean, it means nothing. The SEC could come out and say, hey, just so you know, you have to put a disclosure in that says only Ether in this commodity-based trust is what we're talking about. That's, not a security. And then that leaves everything else, how you, me, anybody transacts in it, still an open question. So they just don't have accountability, and there's no way to force that without lawsuits, which take a long time. And so, yes, they are still operating completely in the gray area, as of right now.
Now, going back to your firm's case against the SEC, does that become reactivated in any way based on what Consensys does? Please ignore my ignorance around this. Like, I don't know how all that would work.
That's fine. I will ignore your ignorance. No, it's complicated. So, our lawsuit was filed back in November of 22. It was denied, or the motion to dismiss from the SEC was granted. SEC just said, we don't have to tell Hodl Law anything. You can't force us to make a decision on Ethereum. He can't sue us. The firm can't sue us. District Court agreed. We filed an appeal. Again, this takes time. So we're just now fully briefed the Hodl Law's appeal of the granting of the motion to dismiss. Our appeal is saying that, hey, a citizen, a U.S. company can force the SEC to answer this when this threat of enforcement looms, large overhead, especially when an agency says they're in charge and they've taken 10 years. It's been about 10 years almost since Ethereum's been out there, to say something. And so we did the briefing, and fortunately, we have an oral argument coming up in front of the Ninth Circuit. I'll send you the details, but I think you can watch that live. Everybody can see me struggle and flounder up in front of the Ninth Circuit. It's on July 18th, and it's going to be, I think, at 9:30 in the morning. And then they're going to make a decision, and that's going to be a big deal if not, it's going to stink to lose, but it kind of means nothing. But if we win and it's reversed, then we get to go back to the district court and actually fight the SEC in discovery, about these issues. And that'll be huge. It'll be monumental because it'll be a Ninth Circuit ruling that covers, the whole West Coast of the U.S. And so, the lawsuit's not reactivated. It's still been going. It's coming up to a critical part right now with this argument. And it is very similar to what's going on in Consensys. And so, rather than the SEC has not made a response to the Consensys lawsuit yet. And so there's nothing that is contradicting what it's done in our Hodl law case. And I'm watching it very closely to see if they do, because yes, if they come out and say Ethereum is a security and let's go off to the races and do this litigation in Texas, then it would almost kind of force the court to say, all right, well then Hodl law can sue you too because you've made a decision. So, they're delaying as much as possible because they don't have to make this responsive filing until I think end of June or early July.
Now, Fred, what's fascinating is that Donald Trump, presidential candidate, former president, of course, has been coming out saying he's the pro-crypto candidate. He has called out Gensler specifically by name, say Gensler hates it, Biden doesn't know what it is, right? I'm paraphrasing. And then you had just at a hearing, I think it was last week or the week before, Senator Haggerty brought it up about Ethereum status, asking both the CFTC chair and Gary Gensler, is Ethereum a commodity? Gary Gensler couldn't even answer, right? So do you think the political pressure starting from Donald Trump is going to force the SEC to capitulate here, that in addition to the skeletons in the closet, they're getting this mounting pressure to getting called out?
They're getting pressure, but they haven't capitulated yet. And it's just basically what I said a little bit earlier on in the interview, which is that the SEC and the Biden administration in general is making the smallest, most non-substantive moves possible to try and placate the crypto vote without actually doing anything that's favorable and lasting. And so, that's the same thing that's going on here, in my opinion. And, I am very happy that Donald Trump is making a lot of pro-crypto statements, but I don't want anybody to forget that it was just as bad under Donald Trump 1, as it is under Biden. He had Jay Clayton. He put Jay Clayton in there, who was also a disaster for crypto. So, I do credit Donald Trump with having his finger on the pulse of the country and knowing where the country is going and recognizing that when 50 to 80 million people own crypto, that's a sizable voter block, especially when a portion of that group says they're going to be single issue voters. So, he's doing exactly what needs to be done. But remember, fortunately, when you're not in government, you can say anything you want to get votes. And then what happens in office is a whole different story. We saw, administration 1. I don't think it was really, I can't remember, but I don't think the campaign was anything. I know he said some anti-Bitcoin stuff when he was president, but he does have, some older millennials advising him that if they are in the right spots, it could be extremely good for the industry. But again, it's not substantive. It's just great campaigning. Let's hope that if he's elected, he'll follow through. But that's about as far as he can go.
Yeah, look, I mean, I think to your point, a game of politics is being played here, and we know how that goes, right? We can't take everything at face value. You got to take it with a grain of salt. I think the one thing we can at least hope for is some of these folks are not against crypto. Like Donald Trump was, I think, more against it when he was president. Now he's not so much against it, but if he becomes president again, he's more neutral. But I don't think, I'm not taking everything he says like, oh, he's going to do this. we got to wait and see. This is the game of politics. Do you
I'll
think?
just say real quick, it
Yeah.
would be much better for crypto if, somebody like Elizabeth Warren went down and
Mm.
she's against this guy. I don't know. I think
I know what you're talking.
John Deaton,
John
one
D.
of the greatest candidates there could be for the Senate. So
Yeah.
anybody in Massachusetts, make sure you're registered, get your ass to the polls or get your absentee ballot in.
Absolutely. And that's a great point because I think you and I and the rest of the people can agree that we haven't heard one word from Biden himself about crypto. I haven't seen anything, not a tweet, not a statement, not a video of him saying anything. And we know who's pulling the strings. It's Elizabeth Warren, so we got to get her out.
Yeah, I slightly disagree. She's pulling the strings on the financial policies. I think there's a handful of people pulling the strings for other things because I mean, I know this isn't the point of the channel, but as someone who spent 15 years, fighting for the rights of elderly, vulnerable adults, it makes me very upset when anybody criticizes Joe Biden because he's a vulnerable adult that can't really make his own choices, and I think it's terrible what they're doing to him.
So, Fred, that threw me off track there. um, so it's crazy. Do you think crypto is going to come up at the debate coming up? If not this one, but maybe the second.
That's got to be something you can bet on in one of those crypto betting markets. I think it is going to come up. I do think it's going to come up, and I think it might come up. If it doesn't come up in this one, it's going to come up in a debate for sure. But if I had to bet, I would put money that it comes up this week
Hmm. Yeah, I think.
because that's something that could also, I mean, that could easily confuse Joe Biden if Trump starts hammering him on crypto and just says like, besides Bitcoin. I mean, if he said Bitcoin and Ethereum and said, Joe, I bet you don't even know what Ethereum is, I think that would be a disaster for Joe Biden, to be honest.
Oh yeah, for sure. Especially, I was not to get too political, but look, these are the facts. Like, there's been reports coming out that Democrats are losing a lot of younger voters. Historically, they've been getting a lot of the young vote. So if they're losing the younger vote, not just because of crypto, but then you add crypto on top of that, it's not looking great for them at all. And I think that's why some of these Democrats are panicking and saying, "Hey, we're stepping away from Elizabeth Warren and Gary Gensler. We're going to side with the Republicans to get the FIT bill out the House, repeal SOB 121." What do you think about that?
I mean, not much to add. You're 100% on topic.
Um, Now there's other things happening with the SEC and other lawsuits, right? We saw they went after Uniswap, then Robinhood. Anything that you're seeing, and then Kraken, of course, they got the situation going on. Anything that you're seeing that would change anything, any dynamic, anybody coming out as a winner, or is too early to determine this?
It is a little too early. So again, we're in what I said at the beginning, which is the SEC is doing a few things that is making it look like they're going to be a little more reasonable without actually doing anything substantive yet. So
Mm.
I did lose track a little bit of Uniswap and Robinhood, and I only started trying to catch up 10 minutes before we started. But my understanding is that there actually are no lawsuits, no enforcement actions yet. Uniswap got the Wells notice, Robinhood got the Wells notice, and there hasn't been any filing. I don't think there's a legal complaint that's been filed yet, which is good because Ripple got the Wells notice and they were sued pretty quickly after that. I will say I couldn't find out about Robinhood, but for Uniswap, they've got the same attorney as Ripple does.
Mm.
And so, I mean, that's just been a money-making bonanza for that firm. I mean, if he gets,
Yeah.
I mean, he's probably, that firm is banking, hoping the SEC continues to say anti-crypto because, I mean, just with Ripple and I mean, Uniswap and Robinhood can also pay these Ripple-like lawyer fees. That actually will, that would be poor for that law firm's business if the SEC tones it down. So they haven't filed the lawsuits yet, to my understanding. That's a positive sign. Coinbase, we're waiting on that interlocutory appeal order. I don't think that's going to be granted. And then Coinbase gets the Ripple treatment. Kraken just lost their motion to dismiss. Again, that wasn't surprising. They get the Ripple treatment, they get to go through discovery, and that's going to be a 2-year process to see what's going on there. And so, yeah, for those cases, that's where we are.
I feel like the SEC is copying and pasting here for these different exchanges, right? Same thing. Oh, you got these coins or securities, blah blah blah. We're not going to say why, but here's a lawsuit.
Yeah, I mean, I guarantee you they take the last one, Control F for the defendant, and well, they don't even have to do that much because you just after you name them once, you just refer to defendant. So they just have to fix the factual. Actually, I've gone through it. They do cut and paste because I remember checking for this, and so yeah. But again, that was pre this. I think there was a big change with this Ethereum approval. I was almost locked in that it was going to take another grayscale like lawsuit, like with Bitcoin, to get that thing moving, but it hasn't. It still might, but it is looking favorable. And so things have changed. Let's see if it's substantive or if they're going to slow play it. Obviously, that's a great segue into SECB Ripple because we're about to get the judgment. And, once the judgment comes through, when you're suing a government or when a government party is involved, you've got 60 days instead of 30 to do the appeal, to file the notice of an appeal. So once we get that judgment, the SEC can delay 60 days on whether they're going to appeal or not. And then, that'll be a huge sign as to know where we're going with this SEC right now.
And Fred, the judgment is going to be with the amount Ripple has to pay for the institutional sales?
Correct. But the more important thing is, what is the injunction going to be? What is Ripple going to be prevented from doing ever again? And so that's the money. I mean, obviously, if it's $2 billion, that would be tough for Ripple. And not really even like a killer, but it would definitely hurt.
Yeah.
It's not going to be that, I would put my money on it's going to be under 25 million. And really a penalty only as opposed to disgorgement. But the key is, what is Ripple prevented from doing? The SEC wants a broad sweeping injunction. They put it in their proposed order that, Ripple can't do anything, that's even remotely like what it got ruled as unregistered securities transactions in the case last year. And Ripple is saying, hey, listen, we won't do anything that you told us we couldn't do, Judge, in this, ruling that you gave last year, but everything else now is completely different. And, in their responsive pleadings, they said how it's different. And, the SEC came back and said, it's not different at all. It's really just the same. And so that's more important than actually the ruling was last year. But what I'm very confident on is that the judge is really going to just do an order that says everything that I said was an unregistered securities transaction, Ripple can never do again. And that's going to be that. And so, that'll probably be it, but there might be some type of language in the ruling. Well, there'll be an order, which I think the order will say, but I think in her opinion, that'll be a little more explanatory. It will say something along the lines of, Ripple said it's changed his contracts by doing X, Y, and Z, and the SEC says this isn't good enough. That evidence is not before me, and I'm not going to rule on that. Obviously, the SEC can bring another lawsuit if it wants to over these contracts that I've never looked at. I just can't see the judge getting into something that hasn't truly been litigated. So it's not going to be that'll be the best win, I think, that's realistic for everybody for Ripple, is that, she's going to say, hey, you want to sue him again? Sue him again over this new stuff, but I'm not touching it, which is the best win we can get right here.
Sure. Wow. So let's say, though, there is a decision where I don't want to use the wrong word here, but they limit institutional sales because they feel those are securities transactions, right? What do you think happens to Ripple's U.S. business? Or maybe it doesn't matter. They can still fund themselves outside the U.S.
I mean, it'll just, I think, solidify the push outside, because again, in the same briefings, they said, hey, all this other stuff happens outside of the US anyway. I think that's unfortunate for the US, but I think Ripple will just move offshore if the order is any more encompassing than, hey, what you were doing is illegal and you can't do it anymore. And going forward, you can't do X, Y, and Z. And she basically rules on something that, I don't think she will because it's not a fully briefed record. But in other words, if it's bad and it's just an order that says no more selling to institutions ever, then I mean, that's just giving the green light to go ahead and move offshore.
Sure.
And
Now,
also, that's when you see Brad Garlinghouse on these news on these interviews, and they're talking about when Ripple IPO now, and he's like, "We're not thinking about that. We're fine. We're this." He's a CEO and he has to do the appropriate spin for his
right.
company. But the real answer is there. I file an S1 registration statement, tomorrow after this lawsuit's over. The SEC is not going to grant it. I'm gonna, Ripple's going to have to go through the whole process. They're going to get, jerked around, and he's basically saying politely, I don't see any chance of working together with the SEC to get this thing IPO'd. And the only thing that's going to change that is a different administration, unless somebody gave the order that the SEC is pro crypto now, but we don't have proof one way or the other. The proof still leads that they're in the direction that they're anti-crypto.
Hmm. And one of the things I was going to ask you, and this is a whole separate topic, and we probably don't have all the details, but Ripple's planning to launch a stable coin. We know the SEC has said here and there, they haven't given any definitive guidelines on this, that stable coins or securities, right? Or depending on how you offer them up. Ripple wants to launch a stable coin. We know they don't need the SEC approval, but could that be used against Ripple? Could the SEC go after them because of this stable coin?
Yeah, and remember the SEC, Gary Gensler, I'm almost positive that he said stable coins are securities vaguely in testimony before, but again, there's no official statement that they are or are not.
Mhm.
So, so you have the fact that stable coins might even be securities still floating out there. There's no definitive answer on what they are, what they not. And again, I could sue you because I get very upset that you haven't properly maintained your facial hair. If, I really wanted to go there. Now, you could file a motion to dismiss and say there's a ridiculous lawsuit, and it is, and the judge will probably grant it. But that's still going to take, even that's going to take 3-4 months for that to work, my lawsuit to work its way through the court. So, and the SEC is the government that judges usually give it a little bit of leeway to. So it can file a lawsuit against Ripple or anybody on stable coins and just work its way through. And I bet a judge would let it go through discovery. So boom, that's 2 to 3 years right there before you get an answer.
What a mess, man. I'm hoping this Fit 21 bill can make it through the Senate and maybe by at least next year and become law, but depending on who's president. But fingers crossed on that.
Yeah, I mean that's really the only way to go, other than fighting it out in the courts, which takes years and years. I did want to add something on the Ripple class action, if you don't mind.
Oh, sure, yeah.
So that is the case that's in Oakland, California. It's a civil case. Most people that follow XRP know what I'm talking about. But the plaintiff tried to get a case going on behalf of a class that anybody who purchased XRP in a certain time period could join the class for securities violations against Ripple. For the same reasons that we saw in the SEC versus Ripple lawsuit, that XRP, falls under the Howey test and is a security investment contract. And so, I probably should have, I held back on posting about this on X because I just felt bad. But, Brad Garlinghouse put out a tweet, a X post, and I think Stuart Alderati did too. And everything they said was 100% accurate, but it was definitely spin from a company that's trying to put the best look on a unfavorable ruling as possible. And what I mean by that is there is some great news for Ripple financially, that the class action was as a matter of law. This is its summary judgment, the same thing that Ripple, the SEC, had last year. So all the facts, everything went through the discovery, and we were at the pleading stage, and the judge said, there's going to be no class action on federal or state securities violations. Now, that is huge for Ripple because this would have been somewhere on the order of a 50 to even over $100 million liability for Ripple.
Mm,
The losses could have been astronomical for them if the case went forward, money wise.
sure.
And so the court said, as a matter of law, these are not going forward. But the matters of law, they were different for federal and state, but they were procedural reasons that did not turn on determining whether the sale of XRP was a security. And just as an aside, Judge Torres, said XRP in and of itself is not a security. But remember, that's just the token itself. You could package XRP as a security in a lot of different ways. I mean, I could think of a lot of ways I could put it together as part of a broader offering. So, what was at stake in this Oakland civil suit is the exact same thing that most of us deal with when we purchase XRP, buying it on an exchange.
Mm,
And there's one claim that was allowed to go forward, an individual claim for a misleading statement by Ripple in the context of an unregistered securities transaction. So it's great for Ripple that the class claims were dismissed because they were mega million-dollar claims.
mm,
This individual claim is very low damages. I think the plaintiff was out, maybe a few $1,000 or maybe $100,000, but we're talking about it was less than $1 million, from my understanding.
mm,
And so it's a very small dollar amount. But the legal question, now the judge didn't rule that XRP bot exchanges is a securities transaction. She just said, I looked at what Judge Torres said, and I disagree as a matter of law that you can say people purchasing on an exchange are not engaging in securities transactions. I'm going to let the jury figure that one out.
wow.
And the jury has to figure that out in order to find Ripple liable, because they have to figure out two things. One, were the statements misleading? And two, was it a security?
Mm,
Because the claim is misleading statement in the context of an unregistered securities transaction. So it would still be bad for XRP holders if the jury comes back and says, yep, buying and selling XRP on an exchange is a securities transaction, but the statements by Brad, David Schwartz, and other Ripple employees were not misleading. Ripple wins the whole lawsuit, but they have this very negative verdict that's out there that's only applicable in California, and no other district court has to follow it, but it's a negative ruling that's going to be out there if something like that came back. And so Ripple is doing their best to spin it as a win, and it is a big win. But if that case goes to trial, then there's a chance the jury could say XRP, when you buy it on an exchange, is a security.
mm. And let's say that does happen. Can the SEC use that case law and against Ripple?
They can't use it in their case with Torres. But if they do file an appeal, they would use that case as persuasive authority to say, look, here's another reason Judge Torres got it wrong, Second Circuit. Look at this other court we weren't even involved in this lawsuit.
Mm,
Look at this other court in California. A jury said that it was a securities transaction. So you should side with us. So it's still a mess, but it's a mess all over. It's not just XRP; it's all these other things that the SEC has alleged are securities, and we just have to see if the market is going to really focus on that or not. Because I think that obviously XRP got hit in the last bull run; it was prevented from really running. I'll give that 100% to the lawsuit.
mm,
I would be a lot more concerned if XRP doesn't run in this bull market because the market has seen all these other tokens, be claimed as securities as the SEC and shrugged off. They've shrugged off the Coinbase lawsuit now. They shrugged off the Kraken lawsuit. So there's no reason to not shrug off what's happening with XRP. So, I'm not worried yet until the run happens, but I'm going to be really worried if XRP doesn't catch fire this time.
Yeah, agree there. What a mess, man. That's just the word that comes to mind, a mess, and we need Congress to act because this is so crazy.
I'll say, I know I forgot to bring this up, but with SEC Ripple, there is this expert witness issue that's kind of hanging out there. If anybody remembers, a witness the SEC had in the remedies briefing was an SEC employee that said, I looked at Ripple's books, and for all these reasons, Ripple can pay 700 million or whatever the astronomical number was. And Ripple said, they filed a motion. It seemed like it was late to me. I don't know why they waited that long, but they filed a motion to say can't listen to this SEC witness. They're trying to do expert testimony, never disclosed him as an expert. We should take discovery if you're going to allow it. That's before Judge Netburn. The remedies ruling is before Judge Torres. The fact that we don't have a response from Judge Netburn yet on that makes me think they've already talked about it. And Judge Torres is either going to say one of two things. You don't need to rule on that. I think the most likely thing, which is good for Ripple, is you don't need to rule on the expert witness issue because I'm not going to find any need for disgorgement. And so I don't even need to take that SEC expert into consideration. And, that's good because then we're only talking about a civil fine, which is going to be low. And, that's why I think it's going to be under 25 mil. So that, because there just needs to be time to conduct discovery if Judge Netburn's going to allow it. And I think she would have to if it was going to be factored in by the court. Nothing prevents Torres and Netburn from talking about these two things. And so the longer that goes on, I think that issue's been resolved and we're going to see a real favorable ruling from Judge Torres.
Man, I can't wait for this thing to wrap up. It feels like it's been going on forever, honestly.
I mean, we're coming up on the 4-year anniversary in December.
Wow. Oh my gosh. Boy, I hopefully there's some resolution this year to many of these things, and we get clear legislation next year, and we can move forward and put all these things behind us.
Oh yeah, for sure.
Fred, always great stuff, man. I appreciate your knowledge and insights. Thank you so much for joining me.
Yeah, let me just say in closing, if anybody wants to go to our website, hodllaw.org, I'm always trying to update it. I added a media page, and if you click on the media page, you can see all the interviews that I've done with Tony. And if you click on them, I'd like you to like and subscribe. It costs you nothing, and it really would help my website.
I'll put a link to that. Everybody check it out.